Good morning. Are you Royal Gonzalez?
All right.
I'm sorry?
Yes.
Okay. This is 25 DCCR 0226. Mr. Gonzalez is charged with burglary of a building. And I'm going to take judicial notice of the court's file. Mr. Gonzalez was previously found not competent to stand trial, was sent to a facility for competency restoration. I have received a report from the John Dunn Behavioral Science Center dated December 23rd of 2025 with the finding that Mr. Gonzalez is now currently competent to stand trial. Included in that is the report of competency prepared by Dr. Cassandra Hayes, and she also makes the finding that Mr. Gonzalez is currently now competent to stand trial. Let's see. In addition, I received from Dr. Madeline Gabe, a letter indicating medications and treatment that also took place. Her finding and opinion is also that Mr. Gonzalez is now competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing.
Nothing to state, Judge.
And so I will at this time, based on that information and those reports, find that Mr. Gonzalez is now competent to stand trial. What is the announcement?
Judge, I received a report, of course, during the holidays a couple weeks ago. I did go out and visit with Mr. Gonzalez to find that our communication was definitely a lot better than previously. I do need a little additional time. I've talked with the state about whether there's going to be any new offers or anything, which he did convey an offer to me that I need to really sit down with Mr. Gonzalez.
Take some time. Let's just do a normal reset, Mr. Gonzalez. Mr. Lewis will be out there to see you again to go over everything, and then we'll find out what we're going to do with your case at the next court date. Okay, you can go back with the bailiff. Are you Camden Jackson?
Yes, ma'am.
And this is 24 DCCR 0114. Mr. Jackson has recently been, or more recently, been evaluated for competency to stand trial by Dr. Krapon. I've received that report and going to take judicial notice of the court's file. The report from Dr. Krapon is dated December 4th of 2025. He makes the finding in that report that Mr. Jackson is competent to stand trial. Is there any other evidence with regard to competency?
Judge, not to competency, but there is a concern that I've come to find out, of course, that the entire time Mr. Jackson has been in custody, he has not been on his medication and not been given his medication, and considering some of the medication he's on, I think it explains a lot with the acting out and things, the issues you've been getting from jail.
Right.
So that's a big concern of mine, if we get him medicated and dialed in, so
Okay.
try to move forward.
So what I'm going to do then is make any other evidence with regard to competency.
No, not with regard to competency, Judge. I have reached out to that jailer. I know earlier, due to the proximity of this violation to his actually being granted probation and his behavior in the jail, I did reach out to her. I think she works a different shift than all of us do. I think she's there all night, so I've had a hard time doing that, but I'm happy if the court needs to speak with her. I don't know that we have proceeded on that count one way or another yet.
Well, no, we haven't done anything because we've been doing competency evaluations. And so here's what I'm going to do. I am going to make the finding based on that report that Mr. Jackson is competent. If you'll make a notation and put it on my desk, I'll contact the jail to find out what they need as far as having him evaluated through their medical staff for any medication. And then we'll see if that will help. And then we'll reset it.
And also, Judge, just, I don't know what kind of help you can provide in this regard, but some of the issues that he has had at the jail with the fighting or things of that nature, or where he may have initially been defending himself and aggressor or things of that nature, but it's a situation where he has asked to be isolated or move away from certain people, and that they've never done it. And so,
There's only so many places
I
for all of
understand.
them is the problem, but I will talk to the jail about that
right,
also.
but I understand the biggest issue with him, of course, is the medication.
Okay, I'll work on both of those things after docket. You
Thank
can
you.
go back with the bailiff. Dakota Kuhn. All right, sir, are you Dakota Kuhn? And this is 23 DCCR 0968. Mr. Kuhn has a motion to revoke his probation, on probation for attempt to commit assault a family member by impeding breath or circulation. One of the or a couple of the allegations have to do, in that motion to revoke with the possession of controlled substance out of Chambers County.
Right.
Mr. Lewis has informed me that they have at this point filed those charges and have them over there. And it's asking for a little bit of time to get with them, get all of that information so we can go forward. So I'm going to reset your case, give him a little bit of time to get everything figured out that he can, get with the district attorney, and then we'll figure out what we're going to do at the next court date. All right, you can go back with the bailiff. Good morning. Are you Michael Murillo?
Yes, ma'am.
And Mr. Murillo has 6 cases, cause numbers 25 DCCR 0377, charged with fraudulent use or possession of a credit or debit card. 25 DCCR 0378, burglary of a building. 25 DCCR 1078, burglary of a building. 25 DCCR 1079, burglary of a building. 25 DCCR 1516, burglary of a building, and 25 DCCR 1517, possession of a controlled substance. Mr. Lewis, what is the announcement?
Judge, this defendant here was one that I don't remember he was on bond, but he entered a rehab facility and then turned himself in once he was released from there. Recently, we completed a program. I did reach out to Mr. Hoffmeyer about this, trying to get a resolution, see if we can come to some type of resolution. Mr. Nichols did give me an offer this morning in regards to that, and I talked to Mr. Murillo about it. We wanted to at least have the opportunity to go over some of that stuff from the facility and other things that he did while on bond with Mr. Hoffmeyer.
All right, so Mr. Murillo, I'm going to reset your case, just a normal reset, to give Mr. Lewis time to get all that information, get it to the assistant district attorney, and we'll get an announcement at the next court date. You can go back with the bailiff. I don't know what to do with that.
I know.
We can have Dr. Holmes try. All right, are you D'Antonio Riggs? And Mr. Riggs is charged with aggravated robbery and cause number 25 DCCR 0975. We had Mr. Riggs evaluated for competency to stand trial. I'm going to take judicial notice of the court's file. It includes the report from Dr. Grapon, which is dated October of 2025. And I'm not sure if I haven't already made this finding. I feel like I would have had a court date since then, but it is and does have the finding in it that Mr. Riggs is competent to stand trial. Is there any other evidence with regard to competency?
Judge, just that I still have some concerns in regards to that matter, especially after speaking with his family on multiple occasions about their interactions with him. When I talked with him, it definitely gives me concerns about moving forward with how we proceed with this matter. I know he's been evaluated before. I would like for someone else to take a look, if that's possible.
Okay. So if you're still having trouble communicating and understanding, the only thing I can do is at this point have someone else take a look. A few months have passed since this was done. There is a history, it appears, with spinal tap as well as hospitalizations at Fannin and in Houston. So obviously there's some history. So I will reset the case. We'll do an order and request an additional evaluation to see if anything's changed since that last one, since it was October, and we'll get Dr. Hamza to take a look at them and see where we are at that point.
Okay.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Good morning. Are you Joshua Smith? Mr. Smith, you're charged with fraudulent use or possession of identifying items 50 or more in cause number 25 DCCR 1439. And Mr. Lewis, what is the announcement?
Judge, after speaking with Mr. Smith and with my client, there is some questions in regards to his criminal history that I think we need to clear up.
Okay.
So I know exactly where we stand on his criminal history moving forward. I think that could affect what the offer of what we possibly on the counter could be looking at.
All right, so I'll just do one normal reset to give you some time to get all that taken care of. Mr. Smith, I'm sure Mr. Lewis will be out there to explain all of that to you. We'll get an announcement at the next court date. You can go back with the bailiff.
Judge, just so the court is aware, if I may, before we begin, with the court's permission, we'd like to proceed on count one. This offer was made in the context of, it's my understanding from the defendant and Mr. Lewis that his parole officer has gone out and visited him in a TDCJ conviction in this case, which is what we have offered, rather than the 1244 that you requested, will revoke his parole, and so he will have to serve considerably more time on that parole revocation than this amount of time. We're just wanting to put this in place to move the case and allow parole to go ahead and move on their issues.
Okay. I mean, and it's a third, so it couldn't have been unless I could, a 1244 wouldn't have been.
Well, we
an
would have
option.
had to make a big stretch.
Stretch.
Yeah.
So-
Okay. All right. And so will Mr. Vincent waive the formal reading of the indictment?
He does, Judge.
And so are you Troy Vincent Jr.?
Yes, ma'am.
And Mr. Vincent, in cause number 25 DCCR 0384, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 11th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vincent is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty in count 1 of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide.
Right away, this case starts with a serious issue: probation revocation. For anyone unfamiliar, probation is basically a second chance given by the court instead of prison. But if the person violates the conditions, the judge can revoke that probation and send them straight to prison. And here's the twist. The court record itself already seems a little confusing about which counts the defendant actually pled true to. That kind of confusion can matter a lot in a courtroom. So the big question becomes, did this young defendant really violate probation badly enough to lose that second chance?
Did you to see what devices qualify as a firearm? If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Good morning. Are you Trevon Alexander?
Yes, ma'am. Good morning, everybody.
Good. And Ms. Prazo, will your client waive the formal reading of the indictment?
Easily, Your Honor. That's not for this.
Mr. Alexander, in cause number 25 DCCR 0831, You're charged with a first-degree felony offense of murder from May 13th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am. She explained it.
Okay, good. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Understood.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the first-degree felony offense of murder. Sentence you in accordance with your agreement to a term of 30 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Let's see, Logan Eaglin, Mr. Perazzo.
Yes, Your Honor.
Good morning, you're Logan Eaglin?
Yes, ma'am.
Mr. Eaglin, in cause number 25, DCCR 0897, and we've gone over this before, but I'm going to go over it, make sure we're all on the same page and you understand everything. In that case, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, March 1st of 2013, in 2 different cases of burglary habitation on that date. And then on September 3rd of 2015, you were also convicted of prohibited substance or possession of a prohibited substance in a correctional facility. What that means is if you go to trial and you're found guilty in this case, and those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison.
Here's where things get tricky. Self-representation is risky. She'll be held to the same standard as a licensed attorney. That means no hand-holding from the judge, and any mistakes are on her head. Audience, do you think she can handle it?
Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count 1 only, just the aggravated assault case, with a cap of 20 years as your punishment, which means you would be leaving your punishment up to me. I can give you 20 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide your case. I just want to make sure you understand the possible consequences if you go to trial and what your options are. You understand all of that? And you want to reject this and go forward with your trial, is that correct? All right, is there any evidence or discovery that hasn't been turned over that you guys are waiting on?
Not that I'm aware of, Your Honor.
So I will set it on the next available trial docket. Everybody will be prepared for trial, and we'll get your case tried as quickly as possible. You can go back with the bailiff. Good morning. Are you Marissa Fortune?
Good morning. Yes, ma'am.
And Ms. Fortune was previously in court, entered plea of guilty in cause number 25 DCCR 1117 to the new offense of credit or debit card abuse, and then entered pleas of true in cause number 24 DCCR 1156. It was a motion to revoke probation, and the agreement was for a 5-year deferred on the new case to continue her on probation in each of those cases for her to be ordered to enter and complete the cognitive track of the ISF program, correct?
That's correct.
In addition, there was restitution in the new case, but I don't
The
see
victim
an
himself,
amount.
it was a credit card.
$301.66.
It was a credit card. The victim was not charged that stuff between the credit card company,
Okay,
if they were actually out. And I haven't heard anything from them.
you have not heard anything from the credit card company, then I'm not going to order it. That just makes it more confusing, I think. Have you heard anything or, okay, thank you, ma'am, and thank you for being here. All right, then, I have received that pre-sentence report, reviewed it, and the update. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, Your Honor.
Nothing, sir.
Okay, so Ms. Fortune, you're going to be given an opportunity today that you likely will not get again, okay? So I want you to take advantage of this. Everybody's willing to work with you, get you the help you need so that you can be successful on both of these probations. But I want to make sure you understand that if you're back in here on a motion to revoke on these cases, it is very likely that you will be found guilty in each of these cases, become a convicted felon, and end up in prison. Okay? Yes, ma'am. So I'm going to find in cause number 25 DCCR 1117 that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but at this time I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. And then in cause number 24, DCCR 1156, I'm going to find sufficient evidence to revoke that probation, but I'm not going to do that. I'm going to continue you on that probation and modify the conditions of it to include that you enter and successfully complete the cognitive track of the ISF program. Again, you do all of this, you're going to be given the tools that you need to be successful. And if you don't take advantage of it, you won't be leaving me many choices. You understand? I'm going to hand you in each of your cases, excuse me, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff.